All right, we'll begin now. So thanks to all of you for joining today on another ad law webinar series here from Venable. My name is Ellen Burge. I'm a partner in the Washington, D.C. office of Venable. I straddle both the advertising law group and the payments law group here at Venable, and I'm joined by my colleague, Chris Boone, who also is in those groups with me. We're looking forward to spending the next hour or so with you. We're going to discuss virtual currency and NFTs and games. This is really an interesting topic. It's a hot topic. It's of a lot of interest, both for developers and others directly in the industry, but also for ad networks and payment processors and all sorts of other service providers to that industry. And for those of us who really do a lot of different things in our day-to-day worlds, this topic hits a lot of different issues that we're going to touch on today. So here are some things about regulatory compliance, some financial services, consumer protection, securities, unclaimed property, money transmission, advertising to children, all sorts of things are going to come up. So this is really in some ways a big broad-based overview, but we're really going to try to get to the heart of some of the issues that are coming up today in that subject area. So we hope that this is a good use of our monthly ad law series to focus in on this topic, cover the ground. Do please send in any questions that you might have. You can submit them through the Q&A function on Zoom. We may be able to get to questions. We might save them, and likely we'll do a follow-up for all of you where we can sort of combine all the questions and do a follow-up piece that everybody can sort of get a nice Q&A afterwards. So we do encourage the questions. This program is also eligible for CLE credit up to 1 hour and in New York and California. So if you're there and you need the credit, please make sure that you listen for the code that we'll give about midway through. And otherwise, let me turn it over to Chris Boone. He'll tell you a little bit more about himself. He's really going to do a lot of the driving today. This is a topic he pays very close attention to. So I hope you all enjoy it. And Chris, why don't we go ahead and get started?
Great. Thank you for the introduction, Ellen. My name is Chris Boone. I am a regulatory attorney in DC. My practice focuses on regulatory compliance issues related primarily to payment processing, cryptocurrency, blockchain, in-game economies, fintech services, and advertising and marketing. So game developers and platform providers are increasingly integrating novel payment technologies and digital marketplaces into their games and platforms, creating a larger and more ambitious in-game economies and interactive experiences for their players. However, as these mechanics become more complex, the regulatory issues also become more complex, and regulators are beginning to look more closely at how these technologies fit within the existing legal frameworks. This webinar will explore how to spot and avoid compliance and regulatory issues that will arise with in-game currencies, cryptocurrencies, NFTs, and loot boxes. But before we can address those compliance concerns, we must first have a solid understanding of these game monetization mechanics and how they are evolving. So first up, in-game currencies. We will use the term here as an umbrella term that will encompass any currency mechanic within a game. Traditionally, these have been centralized, only usable within the game itself. But we are seeing the universe of in-game currencies evolve and expand to include cryptocurrencies and integration with non-fungible tokens or NFTs. The purpose of an in-game currency is generally to facilitate in-game purchases, microtransactions, and they may be earned through in-game tasks, such as completing a mission, winning a competitive match, or just signing in. They can also be purchased with real currency. That's most often with a credit card through a mobile app store or online store. There are two general use cases for in-game currencies from a player's perspective. They can be used to purchase cosmetic items, such as a new skin or apparel for your in-game avatar, and that would in no way confer a gameplay advantage, just changing the way the player looks within the game. The second use case, which is more controversial from a player perspective, especially in competitive online games, is an item that confers a gameplay advantage. These can be items like a potion that restores your health or a weapon that deals higher damage to your opponents. In-game currency can also be used to purchase loot boxes, which we'll discuss in more detail a little bit later, that can contain a random item or multiple items that may be cosmetic or have a gameplay advantage. To manage or balance the in-game economy, game developers will often implement more than one in-game virtual currency. Think gold bars, crystals, gems, etc. One of the in-game currencies will be obtainable only through specific in-game activities, while the other in-game currency will be purchasable. Game developers can balance the competitive advantages by pinning one of the in-game currencies or allowing the player to only use the in-game currency of one type to purchase a gameplay advantage, and with the other type to only obtain cosmetic items. In that way, someone wouldn't be able to just purchase the ability to have gameplay advantages to win, especially in an online competitive match. But as you can imagine, the game developers can be very creative in how they structure their in-game currencies and economies to accomplish an entire variety of different goals. So what about cryptocurrency? Well, sometimes referred to as virtual currency or convertible virtual currency by regulators, a cryptocurrency is simply a digital currency or token that is secured by a blockchain using cryptography and a network of computers that update a common shared ledger. This technology makes it virtually impossible to counterfeit or double spend. A decentralized blockchain, like Bitcoin, is not controlled by any one person or affiliated group. A centralized blockchain, however, is operated by a single entity or a selected group of entities that can control the network. You also have permission or permissionless blockchains and their associated cryptocurrency. A permissionless blockchain is completely open in nature. Anyone can join the network and participate, whereas a permissioned blockchain, only the controller can select who may participate. Think of it as a walled garden versus an open garden approach. It's important to note that under the Visa rules, a card-absent environment merchant that sells cryptocurrency is classified as a high brand risk merchant. It's not entirely clear how Visa defines cryptocurrency in this context, but a key factor will be its ability to be used outside of a game platform as a replacement for fiat currency. In classification as a high brand risk merchant carries important implications. A high brand risk merchant must register with Visa, pay a $500 registration fee. During registration, key information about the merchant is gathered and provided to Visa, such as the merchant's URLs, the principal identities, business addresses, and date of inspections, and approved monthly sales volume. Merchants posing a high risk to the acquirer and Visa brands must be closely monitored. Acquirers must conduct daily monitoring of the high brand risk merchants' activity, including daily exception reporting if there is an exception, and acquirers will generally impose higher underwriting requirements, enhanced due diligence review. Visa may also impose strict disqualification criteria, such as dispute activity levels, and may impose security or authentication requirements. So how is cryptocurrency being used in games? The most basic implementation of cryptocurrency in games is the use of payouts. We are beginning to see esport tournaments use Bitcoin payouts in place of typical USD in their prize pools. We are seeing integration of existing and custom cryptocurrencies into games as an in-game currency for the purchase of items or to upgrade to a premium version of the game. But we're also seeing more involved and complex integrations, entire cross-platforms, cross-game platforms that may be compatible with hundreds of games linked together by a common marketplace in a unified cryptocurrency, with each game also able to share that unified cryptocurrency and have its own in-game currency that may be exchanged with the unified cryptocurrency. As a result, progress in one game can lend itself to another game. These platforms, because they are integrated with a cryptocurrency blockchain, can give rise to advanced marketplace features, including smart contracts. For those of you who don't know, a smart contract is a self-executing contract with the terms of the agreement between the buyer and seller directly written into code. To the extent earned in-game currency can be exchanged for valuable cryptocurrency or fiat currency, a player may be able to earn money simply by playing the game. This has given rise to what is being dubbed as the play-to-earn model, and as we'll discuss in a little bit, raises important regulatory compliance questions. So how do NFTs fit into this? Well, an NFT, or non-fungible token, which you may have heard in the past few months and has been exploding in popularity, is put simply a blockchain-based digital asset with proof of ownership. It is non-fungible in that each NFT is unique and can't be replaced with something else. For example, a Bitcoin is fungible. Trade one Bitcoin for another Bitcoin, and you have exactly the same thing. A rare trading card or your pet cat, however, is non-fungible. If you traded your cat for someone else's cat, you still have a different cat. Or if you trade your holographic Charizard for a Pikachu trading card, you have different cards. They're non-fungible. Non-fungibility is the key characteristic of NFTs. And one major benefit of this technology is guaranteed scarcity and provable ownership. The NFT cannot be forged, and your ownership of the NFT is provable. NFTs can be applied to all manner of collectibles, including in-game characters. You may have heard of CryptoKitties, which was one of the very first NFT implementations, digital artwork, tweets, and even sports highlights. You may have heard in the news back in March, an NFT of a digital artwork sold for $69 million. In that same month, the very first tweet was sold as an NFT for nearly $3 million. So there is big money in NFTs. So with the emergence of this new class of NFT assets, new legal questions arise. What is the scope of intellectual property rights transferred to a buyer? What sort of audit rights will the artist have to ensure proper accounting of royalties? What happens if the underlying NFT platform or marketplace ceases to exist? And also importantly, is an NFT considered a security under the securities laws? We will discuss securities a little bit later on, but I want to highlight that SEC Commissioner Hester Pierce, speaking at the Token Security Summit in March, warned that some NFTs, under some circumstances, could be considered unregistered securities. She noted that the whole concept of an NFT is that it's supposed to be non-fungible. So it's supposed to be unlike anything else, which in general means it's less likely to be a security. But people are being very creative in the types of NFTs they are creating. So given this creativity, as with anything else, you should be asking questions. Pierce also emphasized that fractionalized NFTs, meaning a partial interest in a single expensive NFT could run the risk of being an unregistered security. Notably, a rulemaking petition is currently pending before the SEC seeking clarity with respect to the regulation of NFTs. So we will be closely monitoring if the SEC acts on that petition to provide regulatory guidance. So how are NFTs being implemented in games? The most basic implementation is in the form of trading cards, avatars, and other collectibles. An NFT, for example, can represent a pet that players can breed, battle, and trade. NFTs can also represent land deeds, meaning ownership of specific land within the virtual in-game world. One of the key benefits of using an NFT instead of just a traditional centralized digital asset, is with the player ownership. In a traditional model, the game developer will license the asset to the player. So from the player's perspective, while they might own it, it's really attached just to that game. And if the game stops, if it's an online game and they shut down their servers, go out of business because it's an old game and it's no longer being supported, then their use of that item might completely disappear. But with NFTs, you might be able to take your ownership of that asset outside of the game, and it will exist independently on the blockchain, essentially forever, as long as that blockchain continues to be supported. Sorry. So NFT games are also beginning to allow players to earn money. This can be through direct distribution of cryptocurrencies, meaning a holder of the NFT that might entitle them to a disbursement of in-game currency, which may or may not be represented as a cryptocurrency on a blockchain. Players would also, in some cases, be able to sell their NFTs to other players on a marketplace. And that could be sold either for in-game currency, cryptocurrencies, or in some cases, fiat currency. NFT platforms and the integration with blockchains and cryptocurrencies allow items to cross over between games. In this type of situation, an NFT sword purchased in one game could be used in another cross-compatible game. Of course, there'll have to be agreements between the developers to allow this, but just having that possibility and the rails in place for that really open up the possibilities for what can be done. One important concept with NFTs we're seeing is with minting and melting. So for example, InGame Coin and the platform InGame offers a flexible platform to create, integrate, and scale tokenized gaming assets. The way it works is that you mint the NFT by using the InGame Coin. So each NFT will have this cryptocurrency built into it. Conversely, you can melt the NFT. So if you're the owner and the item you have that the NFT represents is useless to you, you could melt that NFT down to its component cryptocurrency. So if you use 3 InGame Coin to mint your NFT, you would be able to dissolve it, melt it down, and retrieve those 3 InGame Coins back. And that raises important compliance concerns, which we'll get to in a minute. So what about loot boxes? Loot boxes have been around for a little bit. It's essentially a container holding a virtual item of some varying amount of rarity. The player doesn't know what the box will hold when they obtain it and purchase it. And after they open it, they will receive the item. Could be extremely rare, could be something they already own, or something that is extremely common. These, of course, can be purchased with real currency with a credit card, or in-game currency, or may be earned as a reward for completing in-game tasks. Regulators are starting to take notice. The FTC hosted a workshop specifically on loot boxes and related microtransactions in 2019. The FTC also released a staff paper a year later in 2020, and they highlighted some key concerns that they've been seeing with the implementation of loot boxes. Manipulative or confusing mechanics. The FTC emphasized a common concern that some monetization schemes may obscure real transaction costs and other in-game mechanics, including visual cues and sounds may prompt spending and addictive behavior. Spending pressure. The FTC also expressed concern that some games employ grinding gameplay loops and offer loot boxes or other microtransactions to bypass these slowdowns. In online multiplayer games, loot boxes and microtransactions may confer a competitive benefit, pressuring players to spend money for an edge. The Commission was particularly sensitive to the impacts on children. So these spending pressure and manipulative or confusing mechanics concerns are heightened because video games often target children, teenagers, or have a large player base consisting of children and teenagers, even if not being marketed directly to them. The report also highlighted concerns over loot box transparency, particularly if a game uses dynamic odds that vary over time. Players might not understand their chances of winning a particular item. The FTC noted concerns that publishers might offer content creators like popular YouTube or Twitch streamers better loot box odds. For those not familiar, one very popular YouTube type of video is you'll have a YouTube personality just open 100 loot boxes on their channel, and that will be the entire video is them commenting on opening the loot box and seeing what they get. It's a great way to hype up a product and engage with their audience. But as you can imagine, if that content creator has an agreement in place with a game developer such that the loot boxes that they are opening have different odds than the public at large, that kind of relationship would need to be disclosed. Now, we don't know if that's actually happening, and the FTC didn't comment that that's actually happening, but they did note that as a potential concern. The report concluded by observing that emerging research is providing new insights on the impact and use of these mechanics, and they will continue to monitor developments. However, they did not specifically recommend any regulatory action. I would like to take a moment to give out the CLE code. The code is NFT 2021. Again, the CLE code is 2021, and capitalization does not matter. So, what are the regulatory risks with each of these in-game monetization strategies? Federal anti-money laundering and state money transmission risks is one. Securities regulation, gambling concerns, unclaimed property, and also more traditional advertising and consumer protection risks. The Financial Crimes Enforcement Network, or FinCEN, which is the regulator over money transmission on the federal level, and several state regulators have published guidance on how the movement of monetary value through virtual currencies, which is FinCEN's term for cryptocurrencies generally, may trigger money transmitter obligations. The FinCEN and state guidance generally define a regulated virtual currency as one that has an equivalent value in fiat currency or acts as a substitute for fiat currency, which they then define as a convertible virtual currency. That convertible modifier is important because it signifies the ability of the player to take that virtual currency and turn that into money, which becomes the substitute for fiat currency in the analysis. So the term money transmission services means the acceptance of currency, funds, or other value that substitutes for currency from one person, and that transmission of currency, funds, or other value that substitutes for currency to another location or person by any means. The term other value that substitutes for currency is the key here. It encompasses situations in which the transmission does not involve currency or funds, but instead involves something that the parties to a transaction recognize has value that is equivalent to or can be a substitute for currency. So a CVC, a convertible virtual currency, either has an equivalent value as currency or acts as a substitute for currency. And when you have those elements, money transmission regulations can apply if you are the entity that is facilitating the exchange of the convertible virtual currency. It's important to note that the label applied to any particular virtual currency, whether that's digital currency, crypto asset, digital asset, or NFT, is not dispositive of its regulatory treatment. The FinCEN guidance identifies some common participants in a typical convertible virtual currency transaction. You have an exchanger, which is a person engaged as a business in the exchange of virtual currency for real currency, funds, or other virtual currency. And you also have an administrator, which is a person engaged as a business in issuing, which means putting into circulation, virtual currency, and who has the authority to redeem, which means to withdraw from circulation, such virtual currency. And by contrast, a user is simply a person that obtains virtual currency to purchase goods or services on the user's own behalf. It's also important to note that FinCEN stated in its guidance that an administrator or exchanger that accepts and transmits convertible virtual currency or buys or sells convertible virtual currency for any reason is a money transmitter under FinCEN's regulations unless a limitation or exemption applies. So because the convertible modifier is a key to this analysis, is limiting your virtual currency's ability to be cashed out for fiat currency avoid classification of money transmission requirements? Well, maybe not. We have a few hypotheticals I'd like to go over. So, purchasing third-party goods. Let's say you have a platform that facilitates the purchase of items from third-party sellers. This can be either other video games or merchandise in exchange for in-game currency. Although the player cannot cash out, the platform has still created a currency that is being used as a substitute for fiat currency. When the platform redeems the user's in-game currency and then provides the retailer, that third-party fiat currency, to the seller as payment, then the game developer may be acting as a money transmitter in that instance. By contrast, if the platform is the seller, the platform has already received the user's fiat currency and then redeems the in-game currency in exchange for merchandise. Here, the in-game currency is acting sort of like a gift card program. It's important to know in many cases, gift card programs are carved out of the scope of money transmission, but they may be subject to other laws specifically applicable to gift cards and other stored value products. You also have marketplace transactions in which a in-game currency has value because it can be exchanged for goods, cash, or valuable cryptocurrency from other players or a third party. In that case, the platform's movement of the in-game currency between users through the marketplace transactions, gifting or otherwise, could be considered money transmission. It's important to note that the Bank Secrecy Act and its implementing regulations require money service businesses, which includes money transmitters, to register with FinCEN and maintain an effective written anti-money laundering program that is reasonably designed to prevent the money service business from being used to facilitate money laundering and the financing of terrorist activities. Money transmitters must also comply with record keeping, reporting, and transaction monitoring obligations. So is the transmission of an NFT alone subject to money transmission regulation? Are NFTs cryptocurrency? Are they a substitute for currency? Well, the answer will depend on the facts and circumstances. FinCEN has not released guidance specific to the application of NFTs. Traditional NFTs, ones that are truly non-fungible, would not typically function as a substitute for currency. Remember, those are acting as a trading card with a unique value to a specific person and is not fungible or used as an actual currency. However, creative implementations and variations can challenge our current understandings of NFTs, and they can begin to act more like a currency and therefore may trigger money transmission requirements depending on their actual use case. So let's go over a in-game currency hypothetical. Let's say you have an online game that features two virtual currencies, gold and gems. Gold is acquired through in-game achievements, while gems can be purchased with real currency. Gems can also be exchanged for real currency. The game features a marketplace where players can buy, sell, or exchange virtual items they've acquired by playing the game. Accordingly, players who sell items on the marketplace for gems can exchange their gems for real currency. In this scenario, the developer has facilitated the movement of funds between buyers and sellers in the marketplace. The gems act as a substitute for fiat currency because they are exchangeable for real currency. Well, how about with NFTs and cryptocurrency specifically? Let's say a game developer has created a cryptocurrency token on top of a popular blockchain. Players can purchase the token with cryptocurrency from the developer, earn tokens from in-game activities, or purchase the tokens from or sell the tokens to other players for cryptocurrency. The game developer also sells collectible pets with unique traits represented by an NFT. The platform allows players to trade their NFT pets with each other for game tokens. By allowing the players to sell game tokens for cryptocurrency that has value outside of the platform, the token may act as a substitute for currency and trigger the application of money transmission regulations. Much of the focus on securities has been on ICOs, or initial coin offerings, which you may have heard about in the news. But securities regulation of virtual currencies can reach beyond what is typically considered an ICO. The SEC and federal courts will frequently use the investment contract analysis to determine whether a unique or novel instrument, such as digital assets, are securities. The SEC here uses the term digital assets simply as an umbrella term to include cryptocurrency, virtual currency, and NFTs. The SEC's Strategic Hub for Innovation and Financial Technology, or FinHub, recently published a framework for analyzing whether the digital asset is an investment contract and therefore a security. The guidance framework is not a rule or regulation, but rather an analytical tool to help participants assess whether the federal securities laws will apply to their offer, sale, or resale of a particular digital asset. The guidance frames its analysis of digital assets using the Howey test for investment contracts. Under the Howey test, an investment contract exists when there's the investment of money in a common enterprise with a reasonable expectation of profits to be derived from the efforts of others. The framework works through a large number of factors that will weigh towards or against classification as a security. These include, among others, does the digital asset provide holders of the asset rights to share in the enterprise's income or profits, or to realize gain from capital appreciation of the digital asset? Is the digital asset traded on or through a secondary market or platform? Is the digital asset offered and purchased in quantities indicative of an investment intent? Are the proceeds from the sale of the digital asset used to develop the network or platform? Is a digital asset marketed using the expertise of the company or its ability to build or grow the value of the network or digital asset? Do purchasers reasonably expect the company to undertake efforts to promote its own interests and enhance the value of the network or digital asset? Or is the digital asset offered broadly to potential purchasers as compared to being targeted to expected users of the goods or services, or those who may have a need for the functionality of the network? All of these and many, many more factors will be factored into the analysis of a digital asset about whether or not it could be considered a security. And we do not have super clear guidance or practical examples in the NFT context. So we'll be definitely paying close attention to regulatory developments or potential enforcement actions as they occur to get a better understanding of how these factors will weigh in practice. Gambling, our most fun topic. So developers are increasingly using loot boxes to monetize their games, and it's not uncommon for consumer groups to criticize loot box mechanics as a form of gambling. While there's an element of chance in these mechanics, the player is always guaranteed to receive in-game content, even if the player unfortunately receives something they don't want. Industry tends to liken loot boxes to collectible card games. Sometimes you open a pack and you'll get a brand new holographic card that you've had your eye on for a while, but other times you'll end up with a pack of cards you already have. In 2017, the UK Gambling Commission issued a statement that said, among other things, a key factor in deciding whether a loot box has crossed the line into gambling is whether the in-game items acquired via the game of chance can be considered money or a substitute for money. In practical terms, this means that where in-game items obtained via loot boxes are confined for use within the game and cannot be cashed out, it's unlikely to be caught up as a licensable gambling activity. A more difficult question, however, is when the game allows users to sell their digital items obtained through loot boxes to other players. If players can spend $100 on loot boxes, and if they're lucky, and receive a rare item that they can sell to another player through the platform's marketplace for $500, the underlying mechanic begins to look more like gambling. Gambling concerns could arise even when players can only buy and sell digital items with in-game currency. If the digital currency is entirely in-game without any ability to convert it to fiat currency, gambling concerns are mitigated. But what if the digital currency is tied to a larger marketplace through a cross-gaming platform? In situations like these, users could trade their loot box items for digital currency and then use that digital currency to purchase video games that ordinarily would have been purchased using fiat currency. If that happens, then it's conceivable that we could have these same type of gambling concerns. It is also conceivable that clever users could create an informal system outside of the platform to cash out the digital points or currency. Such an informal system may be in violation of the platform's terms of service, but what happens if such a system nonetheless becomes robust and easy to access and utilize without repercussion? There have been several media reports of popular digital in-game currencies being used to launder money. In one example, the ill-gotten gains from a credit card fraud ring were used and laundered through a popular digital currency. So these risks are not entirely hypothetical, but have actually been realized in practice. These are all very important questions that regulators are still dealing with. And of course, when a game targets children or has an active user base that includes children, gambling concerns are only heightened. So, escheatment or unclaimed property. For those who are not familiar, unclaimed property laws require holders of another's property, often including intangible property or money, to turn that property over to the state after a period of inactivity. This is known as the dormancy period, and it's typically 3 or 5 years, depending on the state. The purpose of unclaimed property law is to protect the public by ensuring money and property owed to consumers is returned rather than remaining with the business holding the property. The state will hold the property until the funds are recovered by the rightful owner. So in-game economies and wallet systems can potentially trigger escheat and unclaimed property requirements. This would be the case if they fall under the state's definition of intangible property and it's held by the gaming company. A completely closed off in-game currency, one that can't be transferred between players or exchanged for cash and does not act as a substitute for cash, is unlikely to trigger escheat requirements. This is because the in-game currency doesn't have any real value, can't be used outside the platform, and can't be exchanged. So there's nothing really to turn over to the state. A gold bar that's only usable in a particular game has no use to the state and can't really hold it. It only exists within the game. However, if the in-game currency can be used outside of the game and as part of one of these platforms that incorporate cryptocurrency, NFTs, and other enhanced mechanics, if the game company is holding that property and it's considered a substitute for value and falls under the definition of intangible property under the state law, then it could be subject to unclaimed property once the dormancy period has lapsed. So now Ellen will go over some of the advertising issues with in-game currency.
Well, thank you, Chris. As a mother of a teenager who plays games, I now have an explanation for my credit card bills, a little bit more information to help me out in the future, and I'm a little bit scared about how this is all going to evolve, but excellent information. Let me give Chris a break for a minute. We are going to talk about some of the advertising issues in this space. It's interesting, having been an advertising attorney for a long time now and dealt a lot with the Federal Trade Commission and consumer protection regulators. We see a lot of the same issues pop up now, but with a different underlying facts. So we'll talk about some of this here. What we're facing here is it's really a next wave of affiliate advertising and affiliate marketing that many of us have worked with for many years. So it's really middleman advertising. So we've got, in a lot of cases, an ad platform that is sitting between advertisers and gamers, and advertisers and game developers, I should say. The platform will sort of integrate the advertisers' offers into the game developers' games. They'll promise the gamers, the consumers, rewards for completing the offers, and then when the consumers and the gamers they do complete those offers, the advertiser will get some revenue from that. They'll give a little bit of a cut. Then the platform will give a little bit of a cut over to the game developer, probably a very tiny percentage, but the money is sort of flowing around in two directions there. So something like this always requires careful planning. We do a lot of contracts in this space to sort of set things up on all sides of it, and just to make sure that the agreements are in place. There's monitoring in place to make sure that the advertisers are doing what they're supposed to be doing, the game developers are doing what they're supposed to be doing, the ad platform is doing what it's supposed to be doing in the middle, monitoring to make sure rewards are being delivered as promised, having clear consumer-facing terms and conditions. All of this is really important to this. And one add-on about loot boxes, Chris talked about them, we have a good overview of them, but we're seeing also class action lawsuits in this space. So there are some of the state laws that prohibit unfair and deceptive practices have a private right of action. So in certain states, I think in North Carolina we've seen it, maybe in others, that we've seen private lawsuits filed against big game companies for, issues with not delivering the rewards as promised. In a lot of cases, the plaintiffs are minors. So we've got sort of children's advertising types of issues coming into play. A lot of sort of deep thoughts about how in-game currency distances the player psychologically from real-world value of money, and some of these things that Chris was bringing up that the FTC had looked at. So we are seeing these, although we're talking a lot about regulatory things today, that the private litigation and class action side is thriving. So Chris, let's go to the next slide. We'll talk about real briefly the Tapjoy case. This is a fairly recent FTC case. Tapjoy is operated an advertising platform. They still operate an advertising platform within mobile gaming, and they would integrate offers into mobile games. They promise, in-game currency and other rewards for completing offers, and they ended up getting a ton of complaints from their gamers saying that, hey, I didn't get my rewards, and all those types of things. So they are a true middleman. They would pay the advertisers for each consumer who would complete the offer, and then pay the game developer, again, that small percentage, their cut of it. On the next slide, in January, we had the FTC actually filed an administrative complaint against Tapjoy. They filed it with a proposed settlement agreement. This became final in March 2021. It went through a public comment period first, and this was all to resolve these allegations that Tapjoy violated Section 5 of the FTC Act. Section 5 of the FTC Act just prohibits unfair and deceptive conduct. So this was how this case was teed up. There were allegations in this about misrepresenting the rewards that you would receive, not providing the rewards. In some cases, according to the FTC's complaint, gamers were required to actually spend money or turn over sensitive personal information to get the reward. There were other allegations the FTC made about actually discouraging people from filing their complaint, or contacting customer service, making it difficult, saying things like, if you don't tell us within 24 hours after completing your action that you didn't get what was promised, you have no leg to stand on there. So making it difficult, doing things like if somebody did submit in a complaint that was received, if there was no immediate follow-up by the gamer who was looking for their reward, the company allegedly would say, okay, we consider your case closed, and not do anything to help. So a lot of this, you can see it in the gaming space, but we see these types of issues in other forms of advertising and marketing. We're just now seeing it over into this zone. But why don't we go to the next slide? We'll talk about the settlement. There was no money involved here. What we ended up with was really an administrative settlement, but with the FTC's Bureau of Consumer Protection. But of course, as you can imagine, the settlement prohibits misrepresentations about the rewards or the terms of receiving them, and requires clear and conspicuous disclosure of the reward offer terms. And if anybody wants to know what the clear and conspicuous standard is, you can pull out this case. It's a page-long definition of how you can make something clear and conspicuous, depending on where it is, or if it's a audio or visual disclosure, things like that. So that's all in there. There's also some requirements in there to monitor complaints better, track the advertisers, make sure rewards are delivered, provide an easy mechanism for the gamers, the consumers to use to cancel, things like that. But what we got out of this case maybe is a little bit this is all of interest, but there's a statement that two of the commissioners issued together, criticizing this whole setup and really telling a tale of caution about these ad platforms as being gatekeepers, really middlemen, choke points even, as like sort of sitting between on two sides of this and really having a lot of control over what can go on. And these two commissioners talked a lot about the challenges that game developers are actually facing as being part of this, and then the downstream practices that can hurt gamers, and took this opportunity to say, well, this Tapjoy is really, they said, a minnow next to some of these really large mobile gaming industry players. And I probably don't need to say names. I think everybody can guess who they are. So they continued on for paragraphs and paragraphs about the big giants and how they're extracting huge, portions of sales from game developers, and then that's causing game developers to then revert to riskier practices like using loot boxes and enticing people to spend money on loot boxes because they're trying to make up their revenue somehow. So, from a consumer protection standpoint, these all become a matter of sort of disclosure and transparency and all of those things that are very traditional in our advertising law space, but important to pay attention to nonetheless. So one last quick slide on advertising, and there's a couple more cases. I'm sure we're going to see a lot more of these on all sides, private cases, regulatory cases. The first case up top was a case filed. It was a case that was, there was a lot of press written about it in the UK actually. And here we had the UK Advertising Standards Agency, the ASA, actually banned a couple ads. And they were merely, maybe I don't understand fully, so I'll say merely, but misrepresenting sort of the core gameplay. So this was, these are ads where you would show users pulling pins in a certain order to solve a puzzle, but that particular type of game was actually not available to be played in the games that they were advertising to be downloaded, if at all, until you got like way far deep into the game, and it was really difficult for anybody to really reach that point. So deceptive advertising there. And then another case here we picked up from the FTC last year. This one also it was a sort of a smaller administrative case, but this was a game developer that I think at one point had been certified by the Children's Advertising Unit of the Better Business Bureau, KRU, for being compliant with COPPA, the Children's Online Privacy Protection Act. Turns out, I think that if they were certified at all, it had lapsed, and they were still using this sort of seal of approval on it. So that's, according to the FTC, deceptive advertising. So you do need to be careful. This industry is being watched by regulators. Chris, why don't you take us over and just wrap it up with some best practices? And
Sure. I do want to comment. I did see the Homescapes and Gardenscapes mobile ads, and to provide a little bit of color, and I'm sure you can Google to see the actual kind of images that were used, but they would show a cross section of a house, and there would be a person in one room and maybe a fire in the other room, and then there would be water up above that you could guide down to put out the fire with these pins. But by moving one pin but not another, you wouldn't be able to move it in the right way, but you do in the right order, and then you could put out the fire. But when you downloaded the game and you played it, the actual core gameplay loop was more like a Candy Crush type of game, completely different. And so that's kind of really what they were getting at. It just totally had nothing to do with the actual game that you were playing. So what are some compliance best practices? For developers looking to incorporate virtual currencies into a game or app without triggering potential Bank Secrecy Act or anti-money laundering obligations, the virtual currency should be for in-game use only. No ability for users to sell, exchange, transfer, or cash out any virtual currency they have purchased or obtained. One note about refunds, one of the elements to help ensure that your virtual currency or in-game currency can't be exchanged is by limiting refunds. But in many states, miners are allowed to disaffirm contracts, and that can complicate refund policies. We have seen class action lawsuits allege violations of these state laws when the game developer fails to acknowledge a miner's right to disaffirm the contract. It's important to note, though, that a refund in this instance is different than kind of a free exchangeability of in-game currency. So you can imagine in one scenario, a consumer may be able to earn in-game currency by completing in-game tasks. And if it was freely exchangeable, they can then use that and exchange it for real currency or valuable cryptocurrency. And in that case, it's exchangeable. But if they couldn't exchange it, but if they were a miner able to get a refund for a specific purchase, that would be different. It's a little bit of a convoluted process, but it's important to make these distinctions clear so you can be on the right side of compliance for both of these kind of regulatory regimes. So it's also important to ensure that you make clear that the virtual currency or in-game currency represents a limited, non-transferable license to use a specific feature in the game for personal use and does not represent a property interest of any kind. You can also state in your terms that the virtual currency has no real value in real currency. These are all just kind of best practices to have in your terms of service and to kind of help orient your marketing. You might want to reserve the right to change the purchase price for virtual currency at any time to avoid the perception that it has a set equivalent fiat equivalent value. So for example, if you sell a bag of 100 gold bars for $8.99, you would reserve the right to change that to sell that same bag of 100 gold bars for $9.99 later. That helps reduce the perception that those gold bars have an equivalent value in fiat currency. And of course, as we've been saying throughout the presentation, restricting exchangeability and cash out is an important element to keep your virtual currency outside of the box of a substitute for currency. And so that is our presentation, and we would love your questions.
We would love your questions. We have your questions, but we're at the top of the hour. So we thank you for the many questions that are coming in. We are going to try to address these with you all individually, and we'll do a follow-up piece on this. I believe that this has been recorded and should be available to you all. And we hope that you like the content. If you did, let us know if there's more you want to hear about or more specific issues we can help you with. Please get in touch with us. And I'll thank Chris again for a great presentation, and we'll close it out. Thanks all.
Thank you.